Good afternoon, everyone. I'm Scott Carpenter from the Carpenter Law Firm. Glad you are all able to join me today for this topic of assessment collection challenges and solutions for 2024 and 2025. This is September 17th, 2024. My goodness, time flies. We're in the mid-2020s. And the legislature is meddling in our business. And I want to kind of give you an overview of what's going on and why it presents challenges, and give you some ideas for how we're going to move forward for the later half of the fourth quarter of 2024 and what we're in for in 2025 if the legislature doesn't meddle again. So we'll start here with kind of the environment. What are we dealing with? What's going on? And perhaps a little bit of the why. The legislature believes there are problems. In quotes, what are the problems? What's going on? There are, by some estimates, 10,000 mandatory membership community associations here in Arizona. Community associations is inclusive of condominiums and planned communities, homeowners associations, whatever you want to call a mandatory membership, mandatory assessment, real estate community that's not a condominium. We call them planned communities. That's what the statutes call it. Here in Arizona, 10,000 of them. When I started as a lawyer here in Arizona in 1994, there certainly were not 10,000 of them, but that's the best estimate we have. We have estimates because they're not required to register anywhere, but every year there are more and more that are built. The demand for housing is high, and the legislature believes there are problems. Now, what is the legislature? Two houses at the legislature, a House of Representatives and a Senate. We mirror the federal system in this sense. The House has 60 representatives, 2 for each district, and the Senate has 30 senators, 1 for each district. There are 3 people at the 3 legislators at the legislature for each legislative district, 2 House members and 1 senator. They often run as a group, as a team. 2 reps and 1 senator. Therefore, there are 90 legislators and 1 governor, 90 policymakers, as the press sometimes calls them. And these 91 people make the laws. The legislature believes there are problems. The 91 people believe there are problems with assessment collections in Arizona's community associations. And so they changed the statutes, changed the Condominium Act and the Planned Community statutes. Now, here's what we know. In our world, professional community managers and board members, we expect owners to pay assessments, late charges, fines, collection costs, and attorney's fees that are incurred in collecting unpaid assessments and related fees and charges. That's our expectation. We believe that when owners do not pay their assessments, that they should pay those assessments, and they should pay the cascading consequences of that failure to pay. The late fee, monetary penalties for failure to follow the covenants, collection costs, and any attorney's fees and costs incurred in collecting the unpaid assessments. We believe, this is dogma here, we believe that but for the owner not paying, those attorney's fees and costs would not have been incurred, and that the owner who didn't pay should reimburse the association for the attorney's fees and costs incurred. We believe that. That's the bedrock principle of how the system is set up. And in fact, we believe it so much that it's embedded in the governing documents of the association. That's just how it works. So, that's the environment. The legislature believes there are problems, but those problems compete with how the association operates and how we believe it's supposed to operate. Legislators, and we'll include the governor, the 91 implicitly reject the reality that associations have one source of revenue, the assessments. They tend to believe that when an owner doesn't pay, they don't accept the proposition that when an owner doesn't pay, all the other owners absorb the loss. They tend to think that when an owner doesn't pay, the loss is absorbed just somehow magically. But we know, professional community managers and board members, we know that when an owner doesn't pay, the loss is absorbed communally. There's 100 owners, let's make a hypothetical, there's 100 owners. When one doesn't pay, the loss is absorbed by the other 99, 1/99th by each of them. And we believe that's unfair. Associations expect everyone to pay, everyone to contribute their fair share. But when you talk to a legislator, they think that the association is Chase Bank, that when someone doesn't make their credit card payment, that Chase Bank is a multi-billion-dollar entity, and that when there is a loss, that it's just absorbed into the trillion-dollar flow of a national bank entity. But we know that's not the case. And, oh, it's Chase Bank, it's Bank of America, it's the federal government, they can handle it. But we know that's not true. We know that associations work from an approved budget, and associations are entitled to assume that everyone who benefits from the association's work is going to pay. So the problem is that when someone doesn't pay, the budget could fall apart, and we know that. This is the environment we're living in. I don't have to say it to you, but we know that this is messed up. So the last part of the environment that I want to highlight is really to ask a rhetorical and sort of hypothetical question. When the legislature started this year, and we'll talk about the bill that they enacted, did the legislature convene last summer a data collection task force to study the depth of the problem? And my next slide is the problem. And the answer is no. Before enacting massive reform, did the legislature study the problem? Did they ask around? Did they talk to the attorneys who do this work? Did they convene a panel of professional community management companies and ask them what's going on? Not really. No, they didn't. Did they talk to a group of abused homeowners who have been, under the thumb of terrible HOA lawyers doing bad collection cases? No. So where'd they get all this information? Well, it's a bit of a hypothetical yet rhetorical question. They did not do a study. They didn't gather data. So what did they do? Well, we'll get to that in a second. So that's the environment. No data collection task force. Basically reject the idea the association has one source of revenue when an owner doesn't pay. don't really understand that the association works from an approved budget. So what is the problem? The problem for the legislators is that the owners who don't pay are sued when they don't pay. That's the crux of the problem. The legislators, you could say the legislature, the plural of the 90 legislators, the legislature does not like the fact that owners who don't pay are sued. The legislature hates lawyers. That's fine, I can handle it. They do not like the fact that when an owner doesn't pay, they end up being sued. And they don't like the lawyers charge legal fees. Now, lawyers charge legal fees to our client, the HOA, but we'll get to the contingency problem in a second. Legislature does not like that owners who don't pay are sued. I guess they would prefer that owners who don't pay would never be sued for not paying. And they dislike the fact that lawyers charge legal fees. They also do not like that when an owner doesn't pay, the courts decide that at the end of the case, the loser has to pay the winner's legal fees. The delinquent owner loses the case. The Greenacre HOA says to the court, the Johnsons didn't pay. Judge, please require the Johnsons to reimburse Greenacre for the legal fees we incurred, forcing them to pay. And the court says, under the CC&Rs and state law, that's correct. The winner is entitled to have their legal fees paid by the loser. So courts do that and impose on the loser the obligation to reimburse the winner for the legal fees incurred by the winner in that court case, which means the delinquent owner / loser of the court case has to pay the winner's attorney's fees, and courts do that. And that's part of the problem. The legislature doesn't like that, even though it's compliant with the laws that the legislature has enacted. Owners are sued in court. Legislature doesn't like that. Lawyers charge legal fees, and courts follow the law and impose the legal fees on the loser in the court case, which is the delinquent owner. The owners who didn't pay, predictably, do not like this result, because now they not only have to pay the delinquent assessments, they have to pay the attorney's fees in addition, incurred by the association. Nobody likes to have to pay more. If you didn't pay $900 of assessments, now you have to pay $900 plus the attorney's fees incurred by the association, dragging you to court and winning against you, and it's going to be much higher than $900. Footnote, when I started my law practice in 1994, representing community associations here in Arizona, my hourly rate was $85 an hour. Pretty different than what it is now. There's been some inflation with lawyer hourly rates over the years. Delinquent owners would rather pay the original delinquent amount and be done. Well, who wouldn't in that situation? So when this happens, owners complain to their legislator. What is the complaint? Hey, I concede I didn't pay my assessments for a few months, but look what happened. I got sued, and look what the amount became. It started at $900, and look now it's $5,000, or whatever the number became. That's unjust. And here's what their next sentence is. There ought to be a law. It was $900, now it's $5,000. These lawyers are getting rich on this. Do something, Mr. Legislator, Ms. Legislator. The lawyers are always the bad guy. It's Shakespearean. First thing let's do, let's kill all the lawyers. It's always their fault. The bill that I'm about to talk about, House Bill 2648, passed the House 56 yes, 0 against. It passed the Senate 28-4, 0 against. Why not 60-0? Why not 30-0? Well, in the House, 3 representatives were absent that day. And in the Senate, two senators were absent that day. And at any given time, there may be a vacant seat in either chamber. This topic of taking on HOAs is a good bet for legislative success. The ability of associations to lobby the legislature, by looking at this last bullet point, you could say we're really bad at it. We are bad at lobbying. Just based on this last bullet point, we're bad at it. We need a better strategy, obviously. So what are the types of contingency arrangements, and why did the legislature attack collections? Well, there are basically 2 types of contingency arrangements where the law firm partners with the client in HOA assessment collections. The first one is what I call personal injury contingency. This is billboard lawyers contingency. 1/3 of the principal, let's say $900 is owed to the association. On the lawyer's very best day, the lawyer gets $300 for collecting a $900 delinquency. So we send a demand letter, go to trial, and if the arrangement with the lawyer is that the lawyer gets 1/3 of the amount collected, if it's a $900 delinquency, the lawyer's very best day to send a demand letter, go to trial, and garnish the owner's wages, to go all the way to trial and garnish the wages. On the lawyer's very best day, the best outcome for the lawyer is $300. That's a bad deal for the lawyer for 1/3 of $900. I wouldn't do it. I don't know any lawyers in Arizona who would take a $900 delinquency on a 1/3 contingency. There's too much work involved. Go to trial, do the post-judgment collection work, and at current hourly rates, that's a bad bet for the lawyer. Personal injury contingency, and I'm just using that terminology to describe the 1/3 of the principal. Now, it could be 30%, it could be 40%, it could be higher. It's really whatever arrangement the lawyer and the client agree to enter into, but a percentage of the principal contingency. And then the other type of contingency arrangement is what I call attorney's fees on top contingency. This is where, again, let's assume $900 is owed to the association. But on the lawyer's very best day, let's assume the lawyer incurs $1,500 in attorney's fees for collecting the $900. The owner pays $2,400 total. The attorney's fees are placed on top of the $900, and the owner pays $2,400. The $900 of delinquent assessments is collected, but the attorney's fees are added on top of the $900. A fairly typical contingency arrangement here in Arizona with Arizona HOA law firms. So this is a somewhat typical arrangement what has happened and why House Bill 2648 became somewhat controversial in its path through the legislature is that the bill's sponsor believed, and this is somewhat strange, that Arizona's HOA law firms were doing personal injury contingency, when in fact, what Arizona's HOA law firms have been doing is attorney's fees on top contingency. He testified before 2 legislative committees, and in both of his periods of testimony, he described what HOA law firms are doing in collecting assessments is taking a percentage of the principal. And we know that's not what's been happening. We know that Arizona's HOA law firms doing assessment collections have been doing attorney's fees on top contingency. So the solution that he provided to the problem, as I've articulated the problem here of abuse, when he described lawyers abusing homeowners and described what's been happening in terms of how lawyers do the contingency, he described personal injury contingency. And of course, we know that's not what's been happening. HOAs have not been hiring lawyers to do collection agency contingency, or what I'm calling here personal injury contingency. I've been doing debt collection for 30 years. I have never done personal injury contingency work, never done it that way. And as you can see from the example I've given you here, I'd be out of business pretty quickly. Somebody sends over a $900 delinquency. I can't go to trial and collect $900 and be profitable when on my very best day I get $300. I can't run a profitable law firm that way. And clients want their lawyers to run profitable businesses so that it'll be around tomorrow and the next day to continue to do work. And all clients want a value. All consumers of any business want to receive a valuable resource for a fair fee, but we also want the business to be around the next day. Yeah, you don't want the business that you are using to be out of business because you got something so cheap that it's out of business the next day. You know, you don't really want that to happen. So personal injury contingency has never really been done, and it can't be done based on the example I've given you here. So the legislator who was pushing reform, if you want to even call it that, used personal injury contingency as the example of how abuses were being perpetrated on homeowners. So let's talk about the solution, House Bill 2648. I put solution in quotes because it's just one of those things where I'm not sure what problem we're solving exactly. So the attack was on personal injury contingency collections. Representative Neil Carter, the video of the testimony before the committees is at the legislature's website. You can watch everything that he said. I'm not overly critical of it. It just explains everything that was behind 2648. We call that legislative history, and it's all there. I watched it again in preparation for this presentation. And like I said, he does not articulate attorney's fees on top contingency. He articulates personal injury contingency collection programs. Here's what it does. House Bill 2648, reasonable attorney's fees are only included in the statutory lien if awarded by a court. Now, real quickly, let's remind ourselves what a lien is, L-I-E-N. A lien is a right, R-I-G-H-T. A lien is a right to take collateral if there's a default on an obligation. It's not a piece of paper. It's not a document. It's an abstraction. It's a right that exists to take property if there's a default on an obligation. If I go to the Ford dealership and I buy an F-150 and I agree that I'm going to use Ford credit to finance the vehicle, and I sign all the paperwork and I give them $1,000 down, and I'm going to make payments for 60 months, and I drive off the dealership lot and they I've signed all the paperwork. From the moment I drive off the lot, Ford Credit has a lien on the vehicle, L-I-E-N. They have the right to repossess it if I default on the obligation to make the payments. They have the right to repossess the property if I default on the obligation to make the payments. Lien is an abstraction. I may have signed a document, it's a promissory note, and there may be a document called lien, but the lien is the right to take the property if I default on the obligation. I miss the payments, the repo man comes and takes it, or repo woman, whatever. And so the lien in our community association context is the right to take the property if I default on my HOA assessment obligation. Under statute, that means foreclosure. The right to take the home or the condo unit if there's a default on the assessment obligation. This is bedrock stuff in our world. The lien is automatic under the statutes. It's in the CC&Rs. And the attorney's fees, according to Representative Neil Carter, the attorney's fees are only included in the lien if awarded by a court. So you might be asking yourself, how does putting the attorney's fees in the statutory lien if awarded by a court have anything to do with the personal injury contingency collections problem? Well, it probably doesn't, but it does create other strange follow-on odd issues. Well, if the attorney's fees are only included in the statutory lien if awarded by a court, what he's sort of saying is sue early, sue often, always go to trial, and never settle. We have to get in front of the judge in order to avoid a situation where the attorney's fees are lost or they're in limbo. We could end up in a weird situation where we're suing somebody and we've incurred some attorney's fees, perhaps substantial, and then the owner decides, well, I think I'll just sell my house. And so the owner is in the middle of this dispute. The attorney's fees perhaps are quite substantial, and they decide to sell their house. And the attorney's fees have not been awarded by a court. So the attorney's fees are not part of the statutory lien. There's a payoff given to a title company, but if the attorney's fees have not been awarded by a court, then they cannot be included in the payoff to the title company. Remember, title companies only provide a payoff. They're only there to clear liens and encumbrances for the buyer. Well, if the seller is not obligated to pay the attorney's fees as part of the lien against the house, unless the fees are awarded by a court, then uh, the attorney's fees are not going to be included in the payoff. So this is one of the odd things that could happen. Now, how often does somebody sell their house in the middle of a collection dispute? No, it does happen. So we're suing the owner, and the owner is delinquent. They decide to sell or refinance in the middle of the dispute. The title company asks for a payoff. The attorney's fees are actually not part of the statutory lien unless we get all the way to the end of trial and the attorney's fees are awarded by a court. I don't know that Representative Neil Carter was actually thinking about that, but that is one of the nuanced challenges with the way House Bill 2648 was constructed, excuse me, and enacted. So get to trial and get to the judge as quickly as possible to avoid having this situation occur. So it feels kind of like that old Chicago political machine saying, vote early, vote often. And I don't mean it to sound like that, but it does have this sense of the statutory lien includes attorney's fees only if awarded by a court, creates an incentive to get to trial, get to the judge as quickly as possible. But the longer we wait to initiate these lawsuits where we can get to a judge, the longer it's going to take to have these attorney's fees included in the statutory lien. All right, so what are the options moving forward when someone is delinquent? Let's just do a quick overview of the options. Small claims court is still an option for disputes below $3,500. Attorneys are prohibited from appearing in small claims court in Arizona. It's one of those things where if I have a personal dispute with someone in my life, I suppose I could try to go there and sue somebody for my own personal dispute, but technically I'm not allowed to appear on behalf of a client. Below $3,500, the best you can do is obtain a personal money judgment. Kind of like if you don't pay your credit card and a Citibank credit card gets a money judgment against you, what are we going to do with it? Well, a money judgment can be used to garnish wages or garnish a bank account. Garnishing a bank account has become more difficult in recent years. There are a number of changes in federal banking law that have made it more difficult. If you have a copy of a check that an owner has used to pay their assessments in the past, it's easier if we have a bank account number. But basically, excuse me, wage garnishment is the name of the game with a personal money judgment. Now, if the person is a real estate professional or an independent contractor who makes money with a 1099, it's more difficult. But let's assume the person is a W-2 employee and you know where they work. Garnishing wages is the thing that we can do. Well, you may remember Prop 209 from 2022. This was a citizen initiative that was hotly debated politically. It was an out-of-state effort to limit the ability of hospitals and other holders of medical debt to garnish the wages of people who owed hospitals and other holders of medical debt. And it ended up changing the law that all wage garnishments are limited to 10% of someone's disposable income. It used to be 25%. Well, now it's 10% of disposable income. So this would apply to a small claims court judgment. So, we can still, I say I can't get them, but a small claims court judgment can still be used as a basis for a wage garnishment to 10% of disposable income. If someone's making $50,000 a month gross wages, their net of that might be enough that 10% is going to make a dent in someone's judgment that the association has. It doesn't have to be that much, but it can still be effective. That's small claims court. The jurisdictional limit is the amount in controversy or the amount in dispute has to be $3,500 or below. Justice court, amount in controversy below $10,000. Again, we're seeking a personal money judgment here, and then the same thing, garnish wages or garnish a bank account with the same limitations. Prop 209 also still applies, and lawyers can do this work, and we've still got the same basic limitations. The notion of the attorney's fees being included in the statutory lien if awarded by a court is not so important here because we want the attorney's fees to be included in the judgment. So the idea of the attorney's fees being included in the statutory lien if awarded by a court is really about a foreclosure lawsuit, which is an action to take the collateral when there's a default in the obligation. That's what foreclosure is. It's the real estate equivalent of repossessing the F-150. The foreclosure lawsuit is what we do in real estate to repossess the F-150 when there's a default in the obligation to make the payments to forward credit. The foreclosure is taking the collateral when there's a default on the obligation. It's the same thing. It's also the same as a lender foreclosing on the home when someone doesn't make their mortgage payments. It's the same thing. Let's talk about that. What the legislature really is encouraging in their own way, because when they legislate after a citizen initiative, they're really sort of buying the environment. And they may not acknowledge this, but when Prop 209 was passed in 2022, and they legislate in that environment, they're kind of buying the whole revised statutes as they exist after a citizen initiative. So once Prop 209 was passed, Republican, Democrat, whether you agreed with Prop 209, voted for it or against it as a legislator, as citizens, they voted for it or against it. Once it exists, it's part of the revised statutory environment. So the march to foreclosure, really the legislature is encouraging foreclosure as the standard collection methodology. And with the changes to the statutes over the last few years, the last notice from the Association Professional Management, send it to the lawyer. The lawyer step one is a demand letter. And the step two, now required by House Bill 2648, is an offer of a reasonable payment plan. And then step three is a foreclosure lawsuit. And then this sue early, sue often, don't settle and go to trial. But I mean, I don't mean don't settle. I mean, always settle and get paid. It's the degree to which you compromise that's always the question. I've always said for the entire time that I've practiced, I've always told homeowners, I've always told opposing attorneys, we'll always settle. It's the degree to which we'll compromise in that settlement that's really the question. We'll always settle, but when I say settle, I mean we'll resolve it today. But don't assume that by resolving it today, it means we're going to completely gut and eviscerate our position. If my client owed $1,200, we'll settle today for $1,200, but don't expect us to take zero. That the degree of compromise between zero and $1,200 is the question. We'll always settle today, but don't take that to mean we'll take zero. But these are the steps. This is what the legislature wants, and there's significant question about if I'm right that this is what the legislature is encouraging. We're not sure what the future holds, and I'm a little concerned that owners will complain to their legislators. The battle cry will be, "Oh my goodness, community associations are foreclosing," and all we'll be able to say is, "Well, you boxed us in." Prop 209 made it impossible to do anything with, not impossible, but it made it very difficult to do anything with paper personal judgments. And hey, legislature, you knew that. You legislated House Bill 2648 in an environment where personal money judgments were effectively difficult to do anything with. And you told us that the attorney's fees were only part of the statutory lien if awarded by a court. What's the statutory lien awarded by a court if it's not in a foreclosure case? Now, part of the problem is when Representative Neil Carter testified in both of those hearings and essentially admitted that he wasn't an expert. Our ability in the 2025 session to say, well, yes, we are foreclosing, but that's what you encouraged us to do. And they say, no, we didn't encourage that. So, well, yes, you did, and here's how and why. Is that going to be persuasive? Or are they going to essentially do what I'm fearful of? That people are going to essentially conclude, well, the assessment lien is unjust. The association shouldn't have a lien against someone's home. We'll just take away the assessment lien, and all you'll have is the ability to get a personal money judgment. And that's where I think the real concern is on a moving forward basis, is that the legislature could cause Arizona to be the first state in the country to be stripped of the assessment lien altogether. And this notion here would be the first state in the country where a legislature would say, all you get is the ability to go to court and obtain a personal money judgment and then figure out how to collect it against the owner who didn't pay. And if that means a wage garnishment to get 10% of disposable income, then good luck. And I hope I'm wrong about that. But this is the chess game of, hey, we feel that the only move from where you've placed us with House Bill 2648 is to do this foreclosure maneuver, not maneuver, but to focus on this foreclosure 3-step process. And if we do that, which feels like the only thing we can do, that the groundswell may be foreclosure is fundamentally unfair and unjust, and that the way the Arizona legislature reacts and the community associations' inability to lobby, proven time and time again, and proven most recently by the overwhelming passage of House Bill 2648, would mean that a move to eliminate the assessment lien would leave us in this position right here. We can sue people and get a personal money judgment and let the chips fall where they fall. Then this would be this would be where we'd end up. All right, in a webinar format, the questions have to end up take questions in the chat or the Q&A. Violation fines stay where they are in 2648. Nothing really changed there. Monetary penalties are still collectible if the association files suit to collect the monetary penalties, and then they could be collected at closing. Nothing changed with House Bill 2648, same as it was before. What am I suggesting the HOAs do? I think we have to have a plan. And the plan, as I think I suggested, is that we have to focus on finding a good lawyer that can be articulate about a plan to move forward. Really, the question becomes, what's the value in getting personal money judgments? What's the plan there? And if the plan is good, then, if it makes sense, go ahead and do it. But in terms of effectiveness, demand letters, reasonable payment plans, and a march to foreclosure, that's what I'm recommending to the people that I work with on collections. There is no 10% limitation on garnishing a bank account, Dean. Collection activity that started prior to 9/14. Yes, 9/14 was the effective date of House Bill 2648. It may take a little while to figure out how the effective date of the new law affects collection activity prior to 9/14. The lawyer that started something prior to 9/14 really needs to answer that for specific questions. Collecting attorney's fees that are not awarded by the court. Awarded by the court really has to do with whether it's included in the assessment lien. Those attorneys may still be owed contractually, and there may be a way to get a personal money judgment for the attorney's fees and collect on the money judgment part if they're not awarded by the court, which would include them in the assessment lien. So hard to say. I'm not trying to avoid the question, but some attorney's fees may still be contractually owed on a personal money judgment. wage garnishment for someone who's retired, and it's hard to you can only garnish wages in the W-2 sense. Um, I have seen attempts to garnish other types of payments, but anything other than a W-2 is actually quite difficult. Late fees can still be added to the ledger, absolutely, and absolutely be added to the ledger. The tricky part is now the statutes put some charges on the ledger in the lien, and some charges on the ledger are not in the lien. So what it's intended to do is to confuse what you can tell a title company is in the payoff and what's not in the payoff. Because remember, title companies are clearing the lien in a transaction, in a lien payoff. Title companies are not. That's what they do. They're clearing the lien, and they're not really trying to make transactions difficult for title companies. But that's the net effect: is only certain things can be included in a payoff to a title company. The required information on the collection letter doesn't change. The last letter a management company sends. Amy asks, what is the recommended step-by-step process going forward? There's really 4 steps. The last letter from the association or management company that has that bold language, you're returning this over to a collection agency or lawyer. That's step 1. Step 2 is the demand letter from the lawyer. Step 3, in my mind, is the reasonable payment plan initiated by the law firm. And then if that doesn't work, is a foreclosure lawsuit. And if that, and then from there could be a reasonable payment plan anywhere along there. And hopefully that all works. Here's a good question. Is there any way to force an owner to tap equity via a line of credit? There's no way to force it, but we have seen people do that because there's so much more equity now than there has been with the rapid increase in home values. People would rather keep their home than not. And by foreclosing, we are essentially forcing a sale where the equity of their home comes into play. So there's a way to, that's essentially what we would be doing, is forcing a sale where a bidder at an auction would be gambling that they could take the equity in the home. So that's a really good question, actually. Well, those are all great questions. I just noticed the date on my PowerPoint slide is slightly off. Apologize for that. Well, I really appreciate these questions. Hopefully this has been helpful. If you have any questions about any of this, or if I can help in any way moving forward, I'm always happy to help. My contact information is here, and hopefully you are aware of that, and will contact me via email or give me a call. I'm always happy to help, and I'm here for my clients. I'm here for you. If I can help in any way, I'm happy to do it. Thanks a lot, and have a great rest of your day. Try to keep these within about 55 minutes. I've been successful today. Appreciate your time. Have a great rest of the week. Thanks.